What are we talking about here today? The focus is special needs planning and the fact that it's pretty complicated. And we're going to go over what you need to know. We're going to go over some of the issues you need to be aware of if you have a family member with a disability or with special needs, and you want to be sure that they're taken care of after you're gone. Over the past 35 years in our firm's existence, more than 35 years actually, we have worked with thousands of families with children or other relatives with disabilities. And this is something that we hear over and over and over again. I'm afraid to die. And this doesn't go to our existential fears about the end of life. I think it's much more about who will take care of my child or my loved one with a disability after I'm gone. And that is what this is all about. We're going to talk about what you need to understand and some of the issues that you need to address if you're worried about this. If you're afraid that when you're gone, there isn't going to be that safety net, there's going to be that system in place to support your loved one. So Mike, why don't you go over what we're going to cover here today in more specifics?
Sure. So here's our agenda. A little ambitious in a way, but we want to make sure you have the background as well as sort of delving into the issues. We're going to talk about the basics of special needs planning, what it means. The topic for the day is beneficiaries are complicated. We'll certainly get into that. Trustee challenges, choosing the right person as your trustee. I mean, what's more important? Mark is going to be addressing that a little bit later. Prop 19. If there's an overwhelmingly important takeaway for the day, it's Prop 19 and what it's going to do to property taxes and your plans for your kid. Okay. And then coordinating things. Is it enough to just have a plan without advisors, financial advisors, thinking about insurance? How do you think about that and how do you integrate all of that? And finally, of course, we'll talk about some of the proactive steps that you should take, if you haven't already, to make sure that your child is going to be well taken care of.
And for those of you who don't know our firm, I think it's good to have some background. I think most of you probably do here, but we are very proud of our heritage. We are national leaders and really pioneers in special needs planning. Not so much me, but Mike and my mom, Myra Gerson, Gilfix, and Francis LaPole, who really have been the foundational members of this firm. I believe we were the second firm in the state of California, as far as we know, to do special needs trusts back in the early 80s or mid 80s, whenever that was. Mike, a long time, but we have more experience than really any other firm we know of. And we've worked with literally thousands of families throughout the state of California. We work with people from San Diego all the way up to Wairika throughout the state of California. We can help. And our goal is to provide extraordinary value and peace of mind about your child's future. We try to be thought leaders in this space. We speak about this a lot. We write about it. Mike and I co-authored a book, Special Needs Trust Creation and Management Guide, and we're very proud of our history and the efforts we make to educate the community. Special needs planning is so critical. So as we jump into some specifics, I want to start with a mystery. So Tom and Sarah both leave $1 million for their special needs daughter, Jane. When Tom and Sarah pass away, Jane loses eligibility for public benefits. Assets left to her are exposed to bad actors, and she and her representatives have to go to court to protect and preserve her inheritance. And when Jane passes away, all of the money left for her benefit goes to the state of California. It doesn't stay in the family. Mike and Eve, same situation. They have a daughter with special needs, Kate. They also leave $1 million to support Kate. When they pass away, though, funds are protected. Her public benefits continue. A trusted third party is there to oversee things. They don't have to go to court. Everything continues to run pretty smoothly. And when Kate passes away, the assets left for her go to her siblings and other children. They don't go to the state of California. What's the mystery? What did Mike and Eve do that Tom and Sarah didn't do? We're going to go into that in a second.
And we certainly will solve the mystery a little bit later. So before we proceed, we can say we have a lot of experience, but this is an incomplete list of diagnoses, folks that we've, family members who come in and their kid or a family member have these diagnoses. Remember these things the Kabuki syndrome, Capgras syndrome. I mean, things that you normally never hear about. And there's many more that we could add to this list. So it just sort of makes the point that being disabled means many, many different things. And everybody with if you have a different diagnosis, you need a different plan. If Joe has something different, it's a different plan. You have to think about these things very specifically to the diagnosis that we have before us. So again, our experience is diverse. We don't treat everyone the same because everybody is not the same. Everyone is unique. So with that in mind, again, Mark mentioned the being afraid to die, and the other comment we hear all the time is the diagnosis changes everything. You go along in life and you think everything is fine, and then this diagnosis of a child or another loved one just hits you alongside the head, and you have to change your perspective on life and to think about your planning very differently.
Absolutely. And what do you do if you face this? What is the most important step you can take? Well, we're going to talk about special needs trusts. A special needs trust is one of the most, if not the most important document you will ever sign. If you have a child with a disability, it provides a lifetime of protection for your child, really the most powerful legal tool we have. What is a special needs trust? Well, we wrote a book on this. So if you want to learn about it, it's available on Amazon, Special Needs Trust Creation and Management Guide. But at a very high level, a special needs trust is a trust designed to hold assets for the benefit of a person with a disability without disturbing eligibility for public benefits. There are a lot of public benefits like SSI and Medi-Cal, where if you have too much money in the bank, you don't get them. So if someone inherits money directly, that's a problem. A special needs trust is a way to hold assets for the benefit of an individual, and the assets in the trust don't count against public benefits eligibility, and it has to be an irrevocable trust. So there's some changes you can make once it's set up, but it is irrevocable and really needs to be set up properly up front, and it needs to be part of an integrated plan. So let's go back to that mystery. So Tom and Sarah, remember, they left $1 million for their special needs daughter, Jane, but there was a mess. Her representatives have to go to court. The money ends up with the state of California after she passes away. She loses benefits for a while. They just left it directly to Jane. They didn't set up any structure for her, and it left assets exposed. It meant a bunch of steps had to be taken to protect Jane after mom and dad were gone. Mike and Eve, remember, they left $1 million for the benefit of their daughter with special needs, Kate. Everything worked smoothly. Why? Because they created a special needs trust. They did not leave money to Kate. They left money to a special needs trust for Kate's benefit. They had the properly structured living trust. Their living trust directed money to the special needs trust for Kate. So crucial to create this safety net ahead of time. And in Mike and Eve's case, when their daughter Kate passes away, again, the family benefit, the money stays in the family. It doesn't go to the state of California, as it often can if a special needs trust isn't set up ahead of time. So bottom line is, and we have other webinars on special needs planning. We have our book. If you have questions, talk to us. But a special needs trust is a lifelong legal and financial safety net for the benefit of your child. It's a wise, responsible plan to protect your child with a disability. They can retain public benefits eligibility like SSI, Medi-Cal. These can be a big deal over time. A special needs trust can hold a home for your child. So it can hold property, it can hold real estate, it can hold investments, and it can address that lifelong cost of care, which can reach the many millions of dollars for many individuals. So we're going to talk about how you can cover that and the other pieces of a special needs plan. But really at the core, you got to have a special needs trust. It should be set up as a separate document, a separate trust. It should not be embedded in your living trust. It should not be an afterthought. You should update your living trust, and you should have a separate special needs trust for that child or that loved one with a disability. Now let's talk about some of the specific challenges and why this can get complicated and why it's not as simple. Now, crucial to set up the special needs trust and to make sure your estate plan is up to date. But what are some of the other issues you have to think about? Well, Mike, why don't we talk about beneficiaries? In other words, your child or your loved one with a disability.
So here's a deep insight. Beneficiaries of special needs trusts are complicated. Every diagnosis is unique. Every individual is unique. So we're so careful to talk about the unique needs of your child and make sure, more importantly, that the document reflects it and that your chosen successor trustee understands all of that. Determining their needs. How proactive is the trustee going to be? Do they have to hire someone to be a social worker to visit them every day? Depends on the circumstances. Again, making the point that you tailor your plan to fit the unique needs of your child and coming up with a system to be sure that they're going to be addressed. With many special needs kids now maybe being 40, 50, 60 years old, there are communication problems. So how are you going to deal with that? As parents, you have developed the best possible way to do that, but is your successor trustee going to know how to do that? How is that going to be resolved? And learning to say no. This comes up more often with mental health issues where a child is bipolar and having a bad day. The trustee has to say no sometimes. A beneficiary can ask for things that are irrational, arguably even harmful. So it's not simple to be a trustee. Again, Mark will explore that later. These are some of the issues that they have to address. And keeping in mind, special needs trust is not the end of the process. You have to think about, how is that money going to be managed? What kind of advice is the trustee going to get? What kind of investments make sense when you have a special needs situation? Coordinating the assets in the trust with eligibility for government benefits. Ongoing challenges. It's complicated. Let's look at a couple of others. After you're gone, who is going to be in charge? Again, it's primarily your successor trustee, the trustee who's in charge of the special needs trust. One of the things we recommend so consistently is that you, presumably a parent or a close relative of a child with a disability, that you write what we call a letter of guidance. And it's not complicated. What are the things you would want your trustee to know about your child after you're gone? All of the things that it took you a lifetime to learn. What makes your child happy? What drives her crazy? What are the foods that make the most sense? What entertainment? On and on and on. So the letter, which is an evolving document, you modify it as time goes along. One of the most important and effective ways in which you can deal with this challenge of being as sure as possible that your child's needs are going to be addressed comprehensively and creatively after you're gone. And it goes, as said, to building the right team. It isn't just the trustee. They need the legal help, the financial investment help, a CPA perhaps, social worker perhaps. It goes on and on. Again, everybody is unique when you put that team together. Last couple of points about some of the challenges is not all, but many beneficiaries of special needs trusts receive SSI, that's supplemental security income. It's an income program that guarantees a little over $900, maybe $1,000 a month. Not bad, it's important. But there are rules. There are rules about how that money can be used and what special needs trust money can be used for. Our book certainly addresses this and identifies the issues that your trustee has to be aware of. So one of the most important points is that if the beneficiary child is an SSI recipient, the trustee would never give that child money directly. That can ultimately reduce the size of the SSI check. Rather, the trustee pays the bills and systematizing that, making sure that bills are paid properly, directly by the trustee of the trust from special needs trust funds. And often, if your kid is able, the beneficiary, they keep that SSI money and they enjoy it and they use it. So the SSI rules are not overwhelmingly complicated. We give everybody a workable summary. We've not encountered any difficulties as people sort of navigate the use of special needs trust money with the SSI income eligibility rules. It can all be done. So, with that, I said, Mark, let's talk about choosing a trustee and how you deal with that challenge.
Yeah. So one of the this is arguably the most challenging part of setting up a special needs focused plan is who's going to step in for mom and dad or the caregiver after mom and dad are gone, who's going to oversee that trust, manage the assets, bring that team together, make sure funds are properly distributed for the benefit of your child. This is a crucial decision. And what makes it so hard is that you have to look long into the future. It's one thing if you're just looking for someone who might take care of your kid in the next 3 or 4 years if something happens to you, but you really want to think longer term. So where do you look? Who do you think of when you think of considerations for a trustee of a special needs trust? Well, one, you look to your family. Are there any responsible family members who are capable, trustworthy, and willing to serve, ideally on the younger side? So we have a lot of clients who will name the sibling of their special needs child as a long-term trustee. Now, that doesn't always work, but at least they're around the same age. Hopefully they have a good relationship with their sibling and they can do that. Or maybe it's a cousin, or maybe it's just someone who's a really responsible, good head on their shoulders, younger member of your family who's open to doing this. And it's a big role. So that's the first circle where you'd look. If there's no one there, well, maybe you look to long-term trusted close friends. Is there someone who's been a part of your child's life for a while, ideally on the younger side, who could be open to doing this? So you look to family first, immediate family, then maybe more extended family, then very long-term trusted friends. Now, if you don't have anyone in your personal circle, and this is the case for a lot of families, then you look at professionals. And there are professionals who serve in this role. So that can be a professional fiduciary. There are individuals who have certifications for this. This is what their job is to be a trustee. So you can look at certified fiduciaries. Attorneys do that. We occasionally serve as trustee of special needs trust. Other attorneys occasionally serve as trustee. If you don't have an individual that you like, and when you're doing that, you need to talk to them. You need to interview lots of people, do your due diligence, and I'll give some suggestions for questions you might ask there. Then if you can't find an individual, you might look at a bank or a trust company. Some banks have special needs trust specialists in their trust departments. Now, big banks and big financial institutions are very hit or miss. You might meet with their team and think they're great. 5 years from now, it's very unlikely the people you met with will still be part of that bank. We see that issue, but at least there's continuity, and you know that in theory, someone will still be there as part of that bank. You also might consider naming a co-trustee. So sometimes maybe you have someone in the family who's great, they love your child, but they're not very good with staying organized and staying on top of money and financial issues. Well, maybe you name them as a co-trustee with either a professional or with another family member. Some professionals will not serve with another trustee because it actually can make their job harder. But maybe you have two people in your family where together it's a good fit. One is really good with money, the other is really good at knowing what your child needs. And if you have a smaller trust, or if you just can't find this, there are pooled trusts as well, because all of these areas have fees. So a family member or a trusted friend is absolutely entitled to charging for the time they spend to compensate themselves for the time they spend overseeing the trust. And that can be a really wide range, but professionals, they will almost always tell you up front, hey, if I'm managing a trust for you, here's what my fees will be. I think the majority of professionals are moving towards a fixed fee, like around 1% per year or something like that of trust assets when they're serving. So you need to be aware of all of this when you're thinking about this. And this is something that you really need to discuss with your attorney. We can help you think this through and talk about the trade-offs and talk about questions you might ask. Now, a lot of challenges for a trustee. This is why it's complicated. Beneficiaries, as Mike alluded to, can be very challenging, especially if your child has issues with mental health. We've heard a lot of stories of kids who lash out at their parents. Think of what they're going to do to the person holding the keys to the money that's available to them. You have to be sure that your trustee is ready to handle that. And that's where professionals can sometimes be a better choice, because sometimes their job is really just saying no a lot of the time. So you might have a demanding beneficiary. What does that mean? Is your trustee aware of other resources? Are they aware of public benefits? Are they aware of the rules of SSI and Medi-Cal? Now, they can get help for this. But are they even aware that they can get that help? Do they understand they can hire an attorney? They can hire an accountant. They can hire a financial advisor. So making sure they're aware of other resources and other programs available to support your child or loved one. Do they know how to find quality caregivers? If your child needs a lot of support, again, does your trustee understand the process by which you would even find a caregiver, the agencies to contact and all that? Input from other family members. Do you want to create a structure where other family members, maybe they're not a trustee, but they have a way, you build something in the trust where they will have annual meetings or something like that required, so other family members can have some input. So there's a lot of different ways we can structure that, but you got to be very thoughtful about this. And as you think about different trustees, here are some questions you might ask, both of yourself and of the potential trustee as you're talking to them about this. So first, I think it's really crucial that you talk with the potential trustees, whether it's a family member or certainly a professional. Speak with them ahead of time. Make sure that they understand what this entails and make sure they're even open to it, because you can name someone without them knowing it, but they can always turn down the role when the time comes. So you don't want to name someone who's almost certainly going to immediately resign and say, I want nothing to do with this. Is there a plan for succession? So the special needs trust that we create, usually it's set up so whoever you name, ideally would have a couple of backup trustees to serve when you're gone. Whoever's last on that list can name his or her own backups. I mean, someone has to name a backup if they can no longer serve. So whoever you're talking to, do they have kind of a plan or an idea for succession? What if they get sick? What if they can no longer serve? Do they have an idea of who they would name as trustee after them? If it's a professional, what's their plan? How do they approach financial issues in management? Are they familiar with financial investment strategies? Are they familiar with the requirements of filing taxes? And just at a high level, they don't need to be an expert. They just need to know, yeah, I should probably be talking to a financial advisor and an accountant and a lawyer. Does the person, especially for professionals, do they have experience with special needs trusts? That's huge. You want someone who has done it before if they're a professional or who understands this world. If not, do they know where to go to get help? Do they understand that they can get help? They can use trust funds to get experts to help guide them. So talk to anyone you're thinking of naming in these documents, and you update the special needs trust as the situation changes. So as you set up the trust, you might have one set of backup trustees. Hey, 5 years from now, maybe those are no longer good choices. So you have to stay on top of this and update your special needs trust choices over time, and maybe create new versions of the special needs trust as your situation changes and as your discussions with trustees change. So now let's transition to another big challenge that's new for special needs trust planning if you own property. So if you own property in California, you need to be aware of this. I think this is an image that suits it. This is not a death tax, but it is a new tax that comes in when you pass away. So I guess you could say in some ways it is a tax on when you pass away. So Mike, why don't we talk about Prop 19 and what this means for property taxes for your kid and your child and your loved one with special needs?
I think this is the most important topic of the day. We've talked about issues that people encounter when they're thinking and worrying about establishing a plan. We've talked about the challenges that come up when you're the trustee and the trust and a trust is being administered. But this is something that can torpedo the best laid plans. So what is it? Proposition 19 was a California voter initiative that became law on February 16, 2021. It is in place today. And very importantly, it was an amendment to the California Constitution, not a law. So the California legislature can't fix it. It'll take another voter initiative. And we don't see that happening for a lot of reasons. Okay, so what does it do and what does it mean? Why are we so concerned about it? Prop 19 eliminates some of the multi-year benefits of Proposition 13. You go way back to Prop 13, property taxes were lowered dramatically, and then they only increased by 2%. More importantly came Prop 58. Prop 58 is the third bullet on the slide. What Prop 58 did was incredibly powerful for families. It said that you could pass along your residence to your kids, whether or not they live in it, and property taxes remain unchanged. Now remember, property taxes could be a minuscule fraction of what they would be if they instead reflected today's market value of a piece of property. Number one, the residence would pass along. Prop 58 also said that another $1 million in assessed value of other property also passed to your kids without a property tax increase. So you could have a $4 million cabin at Tahoe, assessed value $400,000 or $300,000 because you bought it so long ago, it would have passed along to your kid without a property tax increase. Same for a rental property that you own. Okay, Prop 19 torpedoed all of that. The great concern we have is the enormous number of special needs families for whom it is so important that the family residence be protected and preserved for the child. Or maybe it's a rental house that is envisioned as the home for your child. Before last February, property taxes would not have increased. Now they will. Okay, so what happens here? Again, we're thinking about protecting your home for your child or having a rental property, either for your child to maybe live in or the income to be a key support. Now, if the residence, let's think about the residence first. If your child, special needs or other, becomes the resident, moves into the house and makes it his or her residence after you pass away, there is limited protection. The first $1 million in assessed value is protected. And Mark is going to go through some examples and some histories to illustrate this more significantly. If it's not the residence, there is no protection. There is a complete reassessment. And we have some numbers a little bit later on that they're just going to knock your socks off. I mean, they're incredible. The financial damage to families if you want to keep a piece of property in the family. So if you have a rental property, a vacation home, a second property, no protection whatsoever from a property tax reassessment that's going to reflect the market value on the date of your death. Taxes could go from $3,000 to $30,000, $40,000, $50,000 per year. So again, if you were thinking that you have your home or another piece of property you want for your child, special needs or not, but particularly special needs, listen up. I mean, we have to deal with this on your behalf and take care of it. We can fix it. Mark, let's go to the example and the mystery.
Yeah, let's compare Tom, Jill, and Andre. This is to really illustrate what Mike just talked about. So let's imagine them in the same situation to start out. They each have a house that's worth $3 million that they've owned for a long time. So the assessed value is only $300,000. That's the Prop 13 value. And yes, $3 million is a huge number. We're very aware of this. It's also not that much in the Bay Area or parts of Southern California. It's crazy how expensive houses are. So we have a lot of clients in this situation. They bought their house 40 years ago, 30 years ago, and the assessed value is much lower than the fair market value. So again, Tom, Jill, and Andre, imagine them all starting out in the same situation. House worth $3 million, but an assessed value of $300,000. Each of them wants to leave the house for the benefit of their child, their daughter. Whether the daughter has special needs or not, this illustration applies. Tom, he passes away. He leaves the house to his daughter. She is like, wow, this is great. I'm going to rent this house out. I don't live here. I'm going to rent it out. Her property taxes go from $3,000 a year to well over $30,000 a year. Jill, same thing. She inherits the house. She lives in it. She lives in this house. And a lot of people thought that when this law passed, well, if my kid lives in my house, there'll be no increase in property taxes. Wrong. In this case, property taxes go from $3,000 a year to over $20,000 a year. Andre, same situation starting out. Again, fair market value, $3 million, property taxes only $3,000 a year. He leaves it for the benefit of his daughter, but because of steps that he took, property taxes stay at $3,000 per year indefinitely. That saves a lot of money. What's the difference? What did they do differently? And how can you take the same steps? Well, very quickly, let's go to the solution. Tom and Jill, they don't like paying advisors. They didn't think this was an issue. They didn't do any planning. So Tom, he passed away. His daughter inherited it. She rented it out. It's not her residence. There are no protections. None at all under the new law. Property tax is fully reassessed based on the fair market value of the home. So they go up to over $30,000 a year for his daughter. Jill, her property taxes go from $3,000 a year to $20,000 a year for her daughter, because her daughter lives there and makes it her residence. Great, we're protected, right? No, only $1 million in fair market value is protected. The house is worth $3 million. So that leaves about $2 million to be reassessed in fair market value. Property taxes go to over $20,000 a year. Andre, what did he do? He worked with us. We've created a Dynasty LLC approach. It's a detailed process that takes about a year, but we can lock in low property taxes. It is possible in California. There are rules that we can use to your benefit. So the bottom line is Andre took steps and he saved his daughter over $1 million during her lifetime. And you might think, wait, $1 million? Come on, Mark, it's a lot of money, $3,000 to $30,000 a year, but $1 million? Let's illustrate this. So I created a simple spreadsheet. I used to be a management consultant. I love spreadsheets. So here's a very simple calculator that I created, what you can save if you do property tax planning versus not doing planning. So let's assume, again, $3 million house, assessed value, $3.3 million house, assessed value of $300,000. Let's assume a property tax rate of about 1.1% plus or minus. And property taxes can, even under Prop 13 in California, they can go up by 2% a year. So let's look at an inherited property with Prop 19 planning, our Dynasty LLC, or not doing that planning, whether it goes to a special needs trust or not. You can see if we lock in low property taxes over 10, 20, 30 years, we keep the taxes low. Look at the right side of this spreadsheet. If you don't do this planning in 1 year, it's a $33,000 difference. In 5 years, $170,000. In 30 years, if your child stays in the home for 30 years, we're talking about $1.33 million in additional property taxes paid. That's money out of your pocket. And if it's a special needs, a child with special needs or child with a disability, that is $1.34 million that is not going to be there to support your child. It's there to pay taxes if you don't plan. So that's really, I think, a point we want to make, that if you have issues with this, we do have a Dynasty LLC and trust process. We've developed this over the last few months. We can prevent future property tax reassessments. We can save your home for your child, and we can preserve critical capital gains tax protections depending on your situation. And so we did a webinar that explored these issues more, called How to Preserve Low Property Taxes, on our Gilfix Law YouTube channel. So check that out if you want to see more examples of how this all works. But this is an issue. If you're concerned about this, talk to us immediately. We are helping a lot of families with this. We've already helped hundreds of families actually with Prop 19 planning and property tax planning. Lock in protections while you still can. Don't wait until it's too late, because if something happens to you and you haven't planned, property taxes will spike, and that can make it totally uneconomical to hold on to a house or a rental property. What if you want to keep a duplex or a rental and you want that to be there to support your child with special needs? If property taxes go up by tens of thousands of dollars a year, that rental property may no longer be able to really support your child. So you have to think about this, and we can help, is the bottom line.
And before we leave this topic, we want to think multi-generationally. In other words, the focus for the moment is on you as the presumed parent of a child with a disability, and therefore we're so worried about your ability to protect the house. But you may have a parent who is going to leave some property to you. So don't just think of this as an issue that you face for your child. If you could inherit if you have a parent, someone from whom you're going to inherit something, and they have real property, this is for them, really for you, but it's for them to think about. Rather than sit back and let it happen, if you have any thoughts about wanting to retain ownership of a piece of property that maybe your parent owns, Prop 19 lies in wait to present this incredible challenge. We can fix it. It takes some very proactive steps that have to be taken. But, think of it that way as well. 3 generations worth of protections we're talking about.
And some good questions from Ken, and one in particular: is there anything in Prop 19 that protects a child with special needs? No, there are no exceptions to the rules. So absolutely not, and that's one of the big flaws that we see in this. We'll try to get some more questions at the end of this talk as well. We have a lot more to get through. Actually, not too much. We're going to get through a few more key issues, and then we'll get you on back to your regularly scheduled day. So
the cost of life.
Yeah, is there enough to support your child, and what can you do about that? And Mike, why don't you talk about just the cost?
Sure, let's go to the numbers. This is so hard to do, but the question is, if you have a child, for example, who has autism, and of course there's great variation. Some folks are completely disabled, can't function at all. Others are high functioning. So these are general numbers, and they can be higher depending on the disability. Of course, they can be lower, but the cost is in the millions of dollars. Don't assume that the government benefit system is going to expand and provide more and more and more. Clearly, resources being set aside to take care of individuals with disabilities and to provide housing, those resources are shrinking, particularly relevant to the growth in the number of individuals who need this help. So much of this comes down to the assets that you can set aside to take care of your child. And obviously, it's particularly troubling if you're someone with modest assets. But let's take a look at this and think about it for just a couple of minutes. How do you get this feeling of security that there's going to be enough money there to take care of your child going forward? If you're blessed with ample resources, of course, 500,000 minimum, $1 million, depends on the kid, but you need to put in enough so that you sleep well at night. One of the most important and relatively straightforward approaches to setting aside enough money for a special needs trust is life insurance. So we'll take just a minute and focus on that and have you think about it. You may have life insurance right now, maybe you don't, but it is a way of locking in a benefit. Many individuals will do a single premium payment where they just put some money in and they buy a $500,000, $1 million policy to know that there's going to be at least that many dollars going into the special needs trust when they pass away, to know that there's something there. And that's particularly important if you have more than one child. If you have an estate of 1 or 2 million and your child needs 1 or 2 million, the child with a disability, do you leave everything for that child and nothing for your other child? I mean, that's a challenge. That's really tough. You know, I will take the liberty of giving you the bottom line on a very personal, very emotional story in our office. A couple came to see us, really going to the bottom line, and they were struggling. They had two kids. They were in their 40s, didn't have a lot of money, and they felt that they were going to have to leave everything to the special needs trust. And this made them just incredibly sad. And they suffered with the thought because they were going to leave minimal assets, for their child who was perfectly vibrant and healthy. Enter the idea of a life insurance policy. You know, it was a simple thought in a way. The wife's mom and dad put a little bit of money in, and they paid enough. They paid about $55,000 or $60,000 to permanently fund a $1 million life insurance policy, naming the special needs trust as the beneficiary. Relative to the benefit, it was an enormously appropriate step. When the wife finally really understood this, she was crying in satisfaction, realizing that they could now set aside some money for their other child, knowing that there was going to be something there for their child with a disability. It solved such a problem for that couple and for that family. So it's not the only way to do it. Again, you want to integrate your thinking about your assets, how you're going to invest them, how much is enough. But again, life insurance is one of the many tools that's appropriate and available to address this need.
And if you have an old life insurance policy, talk to us. We work with some experts who can maybe help you trade in an old policy for a much better new one with zero cost. It's pretty extraordinary. The way the life insurance industry has evolved, there are opportunities in a tax-free way to trade in old policies for much better new ones. Talk to us if you have an old life insurance policy that you haven't touched for a long time.
Which makes the broader point about integrating financial planning. Life insurance is one aspect of financial planning. So, Mark, you know, you're being so creative these days. I'm just so happy to have you talk about this because you're being proactive. You're not just saying, gee, you should think about it. You're doing something.
Yeah, we're working on, and this is something no matter who you work with, I think it's crucial that you have coordinated financial and legal planning, that you have an integrated team to make sure that all your assets are properly titled in your living trust, that your life insurance policies, if you have those, retirement accounts, 401ks, Roth IRAs, that everything is coordinated, that your beneficiary designations are up to date, that you understand what your assets are and where they're going, and that you feel good about how much you have going for the benefit of your child with special needs. So you need to make sure that you have a financial plan. Maybe you manage your assets on your own. If so, hey, find some tools to help project where you might be, but ideally work with an integrated team that can help you think holistically about your own financial planning, covering your own expenses, your own long-term care expenses down the road. That's a big deal. We speak about that a lot. And then making sure that you have enough tools in place to be sure that your child will have that safety net, that there'll be enough there. So does your financial plan truly reflect the long-term needs of your child? We have a few frameworks that we use to help parents think that through. And when you work with your advisor, does your advisor really understand
Mark's audio is fading on us a bit here. Mark, try it again.
Did they
not good.
Talk to your attorney?
You know, Mark, let me talk about this. I hope my audio is better. Yours is gone for the moment and you're frozen. So the idea here is, as you can see, it's a matter of coordinating things, being as sure as you can be that your assets, whatever you have, are going to be maximized. And that means fine-tuning the investments to the situation. And again, if it's a special needs situation, it's different than that vibrant kid who's in college and going on to create businesses. Making sure that family members know what's going on and having a plan for yourself. You have to take care of yourself as well as your kids. So again, getting all of these things integrated, thinking about long-term care insurance for yourselves, perhaps, on and on with the planning opportunities here. So
we're working on building a new tool for a team for this. So a lot of clients have asked us about this, and we're actually working on developing a new partnership for integrated legal and financial planning. And I think this is hugely important when it comes to special needs planning. So again, talk to us if you have questions about this. We're developing a program that we think is win-win for everybody, where everything is integrated. But regardless, whether you work with us in just the legal side or an integrated way, make sure your financial advisor communicates with your estate planning attorney, that one hand is talking to the other, to make sure everything's coordinated, not just once up front, but over time, that everybody kind of knows what's happening so we can be aware of all the tools available, and to make sure that your estate plan is integrated, that your financial plan is integrated, everything is there together, including insurance and other financial products. There's a lot of ways where we can help provide that safety net. And we want to make sure you're aware of all those tools. So the importance of looking at your existing estate plan. So I think many of you here might think, well, I already have an estate plan. I set up a trust a while ago. Well, Mike, why don't you talk about why it's so crucial to take a fresh look?
Sure. I am a meeting today with somebody where his circumstances have changed and we have to change his trust. I mean, significant things. The law changes, personal circumstances change. The nature of a diagnosis, that can change, and that can create the need to fine-tune, restructure certain aspects of your plan. Biggest mistake so many people make is they set up their plan and they put it on the shelf and they just don't think about it. And your estate plan reflects you and your family, so it does evolve. It does need ongoing attention. That's why we have about 450 clients in our Peace of Mind program, where we take care of folks going forward very proactively. So being certain that the structure is right for you, taking into account Prop 19 planning, that shakes everything up. Again, realize that's a brand new development that can be catastrophic if the plan was to keep your house for your child. There's a way of dealing with it, and that's the point. You have to stay on top of these things, know what the issues are, and address them. Estate tax, that could be an issue. That has to be integrated into your thinking. One of the biggest worries we have for so many folks is that they get the standard trust, the standard special needs trust, and it isn't structured to fit your situation. So again, everybody's different. You need to think about it. Be aware that the laws evolve along with you, and talk with us. Watch our webinars, but more importantly, talk with us so that we can be very proactive in talking about your situation and what directly and specifically affects you.
So let's look forward. What do you need to do? So as Mike said, special needs families are hurt by Prop 19 perhaps more than any other. If you want to save that house for someone who won't have the ability to earn money for him or herself, keeping those taxes low is so crucial, or the house will be lost. Let's just face it. For all of this planning, if you don't have a special needs trust and that comprehensive plan in place, there is no protection or safety net until that plan is there, that it's signed and in place, that your finances are coordinated, that your assets are coordinated. Don't lose this opportunity. Right now, this is all top of mind, and you need to work with people who really understand how this all fits together. It's our privilege. If you've already worked with us, let's set a meeting to refresh things and to take a look at your updated situation. If you haven't worked with us, of course, we welcome the opportunity to serve you and your family. We can always set that meeting and think with you and for you about all these issues and how they come together. We can review your existing plan. We can add a special needs trust and enhance your existing plan to really make sure it's up to date. We can help you think about and maybe implement an integrated legal and financial planning solution. We're developing some really exciting new programs around that. And I just want to point out that when we meet with families, we typically bill hourly for those meetings. We want to provide value to you from the get-go. But if you're not sure, if you haven't worked with us before and just want to get to know a little bit more about how we do things, we are happy to chat with you for a few minutes, a 15-minute call, just to make sure that we're the right fit for you, that you're the right fit for us, that we can serve you. So if you haven't worked with us, please contact us. We're happy to chat with you and set that meeting. If you have concerns, let's set that planning meeting. The Special Needs Trust is probably the most important document, along with updated estate planning documents, the most important documents you'll ever sign. Don't delay. If it's been a long time since you looked at your plan, let's take a fresh look at it. Make sure it's all there, that it's up to date, that it reflects your needs and your situations. But set a meeting with us. It would be our privilege to serve you and to help you. You can go to gilfix.com/my-needs. There's a place where you can kind of check boxes for areas you're looking for help in. You can always call us. You can also go to our website and just contact us the old-fashioned way through gilfix.com, or call us 650-493-8070. Many ways to find us, but gilfix.com/my-needs. And if you want us to reach out to you, you can enter your contact information in the Q&A function if you're watching this live. If you're watching this as a recording, use our website. But if you like this, I hope you got a lot out of this. We thank you so much for joining us here today. If you got value out of this, please like the video. If you do later watch this on YouTube, please subscribe to our channel. Please feel free to share this. We know that for every family that does this type of planning, there are probably 4 or 5 families out there that don't even know about what a special needs trust is. So please spread the word. It's our privilege to work with as many families as we can, but we can't help everybody, but we want everybody to be aware of these tools. So let your family and friends know about these really powerful tools. So thank you so much for joining us. We're going to get to just a couple questions here at the end. Any final thoughts you have, Mike, before we go to just a couple questions?
I'm going to be a broken record. Prop 19 is what you need to be thinking about and be sure you're aware of it. If you want that house to stay there for your child, you got to talk to us. I mean, don't delay. A couple of questions kind of go to this point. One asks, who was behind Prop 19? Who pushed it? Of the $42 million that was reportedly spent to support it on ads and so forth, $39.5 million came from the Realtors Association, because this is going to dramatically increase the number of homes that are going to be sold, because people just won't be able to afford retention of home ownership. So that is it's a public record. It's not casting aspersions. And they will support the retention of Prop 19 going forward. So will the teachers union, so will the government employee unions, because dramatically more money will be going into those coffers. So don't think there'll be a public revolution over this where everybody's behind its removal.
Yeah, there was an attempt to overturn it, and they came up well short of the number of signatures needed. Maybe they'll get the signatures in the future, but hope is not a strategy. Let's just make that clear. Hoping that a law will get overturned or changed, that is not a good strategy when we're talking about literally hundreds of thousands or millions of dollars at stake for your family.
Sure. I got a good question from Ken, is about where you have a younger person in the family, not old enough to be a responsible trustee. Could you, for example, name a bank or a professional to be a trustee until the child, who is now maybe 15, becomes 25, 30, 35 years of age? Of course you can. Of course you can. And that's often the plan that people adopt. There's a lot of flexibility there. And yeah, we do know of financial institutions, banks that accept special needs trusts. Not all do. When they do, there's often minimums. You have to have at least, for example, $2 million in the trust or they won't take it. So yeah, we are familiar with financial institutions in the Bay Area that are willing to serve as trustees of special needs trusts.
And I see a couple of folks have given us their contact information. We'll reach out. And I think, along those lines, I think it's a good, let's just reemphasize, talk to experts. Don't work with someone who dabbles in special needs planning. This is an area that requires specialization to think holistically about it. So creating your core estate plan, your updated living trust, your updated powers of attorney, that updated special needs trust, that's key. But you need to make sure everything fits together and that you're thinking about this holistically. So we can help be that thought partner to you and that advisor and help you craft that plan. But and just as importantly, we can be there for you and your family over the long term. That's our privilege. And there's some clients I've met with that originally worked with you, Dad, in the late 90s when I was in high school or college. And it's such a privilege to get to serve families for many years and even decades as their situations change. So regardless of, we hope we get the chance to work with you, but even if you don't work with us, we hope you get help and that you set this plan up and you think about it holistically, because the stakes are so high when there's a child or a loved one with a disability. Who's going to support them? How are they going to be supported? Special needs planning is it. So let's be aware of these issues and let's put great plans into place. But again, I hope you guys got a lot out of this. Please spread the word. Subscribe to our Gilfix Law YouTube channel. But most importantly, I hope everybody is staying safe, sane, and healthy, as my mom likes to say, and that everybody's doing okay. And I think on that note, we are going to wrap things up. But thank you so much. Thank you for all of you who are going to reach out to us. We appreciate it. And I hope you have a great rest of your day. Take care.
Bye out.